needs to come before the court this morning is State of Ohio versus Nodal. And we have council table full and many observers, so we should get right into it. And thank you for proceeding. Evidently, there's no reason to wait for anybody else, right? Okay, all right. Because it's still about 10 minutes early. Anyway, each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. You know the procedure. Just tell me how much time you want to reserve. Please don't mention the names of any children or victims. We are recording this. It is videotaped and will be presented on YouTube, so please stay behind the lectern. And trying to think if there's anything else. I think that's it. All right, we're ready to listen anytime you are. We've read the briefs and prepared to hear oral argument.
Thank you. I'd like to reserve 5 minutes for rebuttal.
Thank you.
And may it please the court, my name is Stephen Nodal. I represent the appellant Reuben Nodal. Mr. Nodal was charged with obstruction of official business and resisting arrest, and it all relates to the same incident where there was his brother, who was a combat vet from the war on terrorism, served in both, I believe, in Afghanistan and Iraq, and he has PTSD, and he was having a mental health episode in which Mr. Nodal went there to assist, to help talk him down and to de-escalate the situation so that when the police came, it wasn't going to result in an instance where there would be physical harm to anybody, including the police. And Mr. Nodal's partner, Sergeant Kyle Galinas, who works for Lorain Police, ensured that there was an alert in the system with Lorain Police to say, hey, if there's any issues with David Nodal, Reuben's brother, that they call Reuben. He can be very helpful to help de-escalate the situation, so that so that the situation doesn't escalate into where there is physical harm or that it threatens anyone's physical safety, including the officers. So that's the pretext, that's the background to this incident. And what ultimately happened was that the police got too tired waiting and for the situation to de-escalate, and they misinterpreted Reuben's actions, and they all ganged up on him and cuffed him up, and that's where they alleged that he obstructed official business in preventing David's arrest, and that Mr. Nodal resisted his own arrest. Now, the jury acquitted Mr. Nodal of obstruction of official business. However, they found him guilty of resisting arrest, which is ultimately what we're here for today. And the problem with the jury's finding of guilt is that they were poorly instructed. The jury was not instructed as to all the elements of the offense.
So the jury instructions start with the main elements.
Yes.
Then there are definitions of the main elements.
Correct.
And some of them apply and some of them don't, based on the facts, or maybe they all apply and should be given to the jury. But did the judge have those first main elements, telling them what the elements of resisting arrest?
He had the, if I recall, he talked about, he mentioned about lawful arrest, because you are allowed to resist an unlawful arrest, so there has to be a finding that the arrest was lawful. However, when you get into warrantless arrest, which is what this was, there has to be a finding with essentially probable cause, for the warrantless arrest to be lawful, and that instruction was not in the jury instruction, and that should have been in the instruction, because first of all, it's part of OJI, the Ohio Jury Instructions, which are basically the standard bearer of jury instructions.
Right. But are they required, every single instruction? And there's multiple instructions based on that statute. Are all of them required?
In this case, yes. In this case, yes. Now, that doesn't mean for every case that it's required, but in this case, yes. Because, the facts of this case rested, Mr. Nodal's defense 100% hinged upon the fact that this arrest was unlawful, which then hinged upon that there was a lack of probable cause to arrest him. And the fact that the jury acquitted Mr. Nodal of obstruction opened that door for the jury to potentially find that there was a lack of probable cause for arresting him for obstruction. And so, that was his defense. And in fact, Mr. Nodal said it himself when he was being cross-examined in trial. And when the prosecutor just point blank asked him, well, what's your defense to this? He said that the arrest was unlawful. And so, and the facts that were developed in the trial support that. And so, but on top of that, his trial counsel, for all the things that I take issue with, one of the things he did do right was that he filed a proposed set of jury instructions, written instructions, that included the full set of the instructions for warrantless arrest, that included a finding of probable cause. And yet the judge himself just left it out.
So there's a difference in the law and the briefs here. Proposing an instruction and it not being read to the jury, that's not, legally, is that you said an 8th district case where that counts as some type of objection, but is that the law here in the 9th district, or what's the?
I think it's the law in the state of Ohio. If you go back to State versus Wolons in the Ohio Supreme Court in 1989, the Ohio Supreme Court, the Williams, I believe Williams from the 8th district in 2019, it ultimately traces back to the Wolons case in the Ohio Supreme Court in 89 that basically said that a filed written proposed instruction preserves the issue for appeal. And so therefore, the fact that trial counsel failed to object to the judge's poor instructions does not waive the issue before this court, does not require plain error analysis. He did preserve the issue because those written instructions mirrored OJI, which again, that even though OJI is not the absolute requirement that courts have to abide by, but they have to at least give a good reason as to why they're going to deviate from it, whether it's based on the facts of the case, or maybe there's been a change in the law and OJI hadn't been updated yet. But those factors weren't present here. There was no reason for the trial court to deviate from OJI, but the trial court on its own just left out the most critical part of the instruction that required the jury to find probable cause in order to find that there was a lawful arrest. And because without a lawful arrest, Mr. Nodal cannot be convicted of resisting arrest. So ultimately what we have here, Mr. Nodal was found guilty by a jury without the jury making a finding of guilt on each and all the essential elements of the offense. And that's, that's a deficient jury verdict, and as a result, based on that alone, this conviction should be reversed. And so there was no reason for the trial court to leave out that instruction, and I think trial counsel was expecting that the judge was just going to give the OJI instructions as he proposed, because most of the time, that's what most trial court judges do. And I think as a result, he just didn't catch the fact that critical element was missing for whatever reason.
And the element wasn't missing, right? We're not talking about the essential elements, because did the judge read, "No person shall recklessly or by force resist or interfere with the lawful arrest of the person or another"? Was that read to the jury?
That was, but I'm talking about, there's 3 parts to warrantless arrest.
Right, there's definitions of what.
Right.
Right.
But the 3 parts are all required, because under OJI, which is what trial counsel proposed, under warrantless arrest, there's 3 parts, and they all have and, they're not ors. And so, number 1, where the offense which the arrest being made was one for which the defendant could be arrested, that's the only part the judge included. The other 2, for 2 and 3, he left out, and there was no reason to leave them out. And you see after 1, it says and then number 2, whether the arresting officer had authority, and then after that it says and. Number 3 is the most critical part. It says a reasonable police officer under the facts and circumstances and evidence would have believed that the following elements of obstruction of official business had been committed by the defendant, and then goes into the elements.
Now, if that's left out, maybe it was unintentional. If there was an objection, couldn't the court have had an opportunity to argue, or the attorneys argue about that instruction, or potentially add it?
It would have been, this would be a cleaner record if the trial counsel had objected, and certainly could have given the judge the opportunity to fix it. But at the end of the day, the judge was put on notice by the written proposed instructions that this was the element to be included, and this is how the jury should be instructed. See, and that's what the State versus Williams case from the 8th District says, and if you look at the State versus Wolon's case from the Supreme Court in '89, that's what that says too. So the issue has been preserved. However, I did argue plain error as well, and also argued ineffective assistance of counsel on my second assignment of error for his failure to object, because there was no reasonable, that's not a reasonable strategy to deviate from, you file a written proposed instructions and then in trial just not show up and defend that. There's no reasonable strategy behind that at all, and there's no perceived benefit to the client that would come from, oh, I'm just going to do it differently, I'm just going to not object, I'm going to let the judge just leave out the critical instruction. And what's perplexing about trial counsel in this is that He also filed a trial brief that said, hey, our defense is going to be that this wasn't a lawful arrest. So he knew ahead of time. He filed the brief on July 6th of 2021. But then in the trial itself, he just does nothing to develop that defense in cross-examination, or even with Mr. Nodal's direct examination. And with Mr. Nodal himself, who had to take it upon on his own to say, my defense to this is that this arrest wasn't lawful. And then trial counsel made no mention of it, including argument. So it's perplexing as to how he says one thing before trial about, yeah, this is our position, but then he just abandons it in trial. And it's one thing to change your strategy to try a different strategy, but there was no other strategy. Like, there was no other path that he took in Mr. Nodal's defense. He just abandoned the defense that he was going to do and then did nothing else. It's not like you abandon one defense and say, hey, you know what, I think this defense is going to be better. That's not what happened here. And instead, he just abandoned the defense for no apparent reason and to no benefit of Mr. Nodal. And in fact, it prejudiced Mr. Nodal because ultimately, when the jury did not receive the instruction on probable cause, they had no choice but to find him guilty. Like, there was no other option. And
Counsel, you're into your rebuttal time.
okay, and I'll just finish my point. If the fact, while an acquittal of the obstruction charge is not automatic as finding an unlawful arrest, but it opened that door to and gave the jury a path to where they could have considered, if they had to consider the probable cause, they very well could have acquitted Mr. Nodal. So I reserve the rest of my time.
Thank you.
Your Honors,
Good
may
morning.
it please the Court, my name is Scott Bowles, and I'm here today in my capacity as a certified legal intern representing the state of Ohio. The state of Ohio is respectfully asking that this Court affirm the conviction of Mr. Nodal for two reasons. First, the trial court's refusal to adopt a proposed jury instruction does not constitute reversible error. And second, that Mr. Nodal was not afforded ineffective assistance of counsel. To my first point, a threshold question here is what the proper standard of review is. There's a dispute about that between ours and the appellant's briefs, and we propose that the proper standard of error is a plain error review. This is because under Criminal Rule 30, jury instructions are required to be submitted during the trial, and a failure to do so waives that except for harmless error, or plain error review, sorry.
But the Ohio Supreme Court in Woolens doesn't say that, do they?
In Woolens, thank you for asking that question, Your Honor. The Ohio Supreme Court essentially says, actually I'm just going to quote the language here, where the record affirmatively shows that a trial court has been fully apprised of the correct law governing a material issue in dispute, and the requesting party has been unsuccessful in obtaining the inclusion of that law in the trial court's charge to the jury, such party does not waive his objections by failing to formally object thereto. However, this case is distinguishable because here there is not a material issue in dispute. It is correct that Mr. Nodal, on his direct or cross-examination by the state, did say, and I'm going to quote here, it was an unlawful arrest. That's found on the transcript at page 254. However, that was the only indication that the defense counsel, outside the trial brief, which was submitted 2 months in advance of the trial, that they would argue that it was an unlawful arrest. The prosecutor never followed up with any more questions. The defense counsel on redirect never followed up with any more questions pertaining to the legality of the arrest. Therefore, the trial court had no indication that this would be argued during the closing argument when it hasn't been argued during the entire trial.
So it wasn't argued during closing argument either?
That is correct, Your Honor.
Okay, now let me ask you this. So defense counsel filed proposed jury instructions that included the language about, probable cause to arrest, and then filed a trial brief on it. And then at trial, didn't mention anything about it, but yet the defendant himself said it was unlawful. How does that not constitute ineffective assistance of counsel?
Your Honor, I will emphasize the fact that this is a single sentence that was said during his testimony. It was not something he said over and over and over during his trial. It was just a single sentence. Further, although failing to argue a client's case can constitute ineffective assistance of counsel, the cases that this court and the Ohio Supreme Court have cited where that has happened it is so detrimental to the client that it completely ruins any chance of winning that they have. For example, in the Ohio Supreme Court case, the Ohio Supreme Court ruled that even conceding guilt in an opening statement is not ineffective assistance of counsel, because it could just be a pivot in trial strategy.
That is incomprehensible to me, I have to be honest with you. I'm just being, if you were arguing in front of the trial judge for sentencing purposes, I can see that. But to go in front of a jury and plead not guilty and then say, oh, he is guilty, how that could ever be a trial strategy?
I actually could see it as a trial strategy, because maybe there's a lesser charge if they admit to it, they become more credible.
Well,
and they
that's
wanna
true, it is
just-
something like that. We shouldn't argue up here, but. But unless there's, going for a lesser included or something, which I don't think was the case in that particular, Supreme Court case or whatever it was that you were referring to.
And I'd also like to point the court to another Ohio Supreme Court case. This is State v. Bradley. That's found on page 14 of the our appellate brief. In that case, the counsel did not interview any state witnesses before trial, and failed to make an opening statement, and failed to humanize the client during the guilt phase. This was a capital case, so there was a guilt phase. And the court still found that it did not constitute ineffective assistance of counsel.
Obviously, every one of those cases is going to be very fact determinative, which brings me back to this case. Isn't it very fact determinative too? Because this is a very unusual case. You don't usually have the police calling somebody to come and intervene and help them in arresting somebody, and then they end up being charged with obstructing, which a jury found them not guilty of, and also charged with resisting arrest. So there is a whole conglomeration of facts here that are not in the usual case. So wouldn't that be reason enough for the trial court to have charged the jury that there had to be probable cause, that there had to be, that wasn't an unlawful arrest?
I think more than anything, it highlights the emphasis or the change in trial strategy. And I would once again reiterate that there was no indication during the trial that they would argue that the arrest was unlawful. Rather, they were focused on portraying it as self-defense, for lack of a better phrase. They even requested a jury instruction on self-defense for the resisting arrest charge. They did not get that jury instruction. The judge wouldn't allow it in, but it just highlights the fact that this was a change in trial strategy. It was not, it was not deficient conduct.
I was going to say, when I was reading this, it was very fascinating to me too as well, because when you're arguing self-defense in regard to an unlawful arrest, you can resist an unlawful arrest. So how does self-defense differ really from probable cause?
Your Honor, in my appellate brief, I highlighted a number of kind of out there examples of where jury instructions hit their natural limit. And here, like I said, there was no indication that they would argue it, so the judge would have no reason to believe that this would be an element that would be something that they are attacking in closing arguments or otherwise. Further, even if the omission of the jury instructions was error, it's not an obvious error. In order for it to be an obvious error, it has to be clear at the time the decision was made. Here, whether or not a decision or a jury instruction should be given is subject to an abuse of discretion review, as to whether it's factually warranted. And it is not factually warranted in this case. And it's not factually warranted in this case because there was no indication that the trial counsel would argue that there was a lack of probable cause in the closing arguments when they had not done so through the entire trial. And even if it were an obvious error, even then it does not rise to the level of something that should be deemed to be plain error by this court. And that is because plain error review should only be utilized in egregious cases when there would be a manifest injustice if the error was not corrected. And a good articulation of that is found in State v. Chisholm in 2006 out of this case. It highlights the rarity of the plain error doctrine when it should be used with the utmost caution and save for exceptional circumstances, when it was clear that the outcome would be different if the instruction in this case had been given. Here, it's not clear that the outcome would have been different. Rather, counsel, both in his brief and during his oral arguments, has stated that it could be different, not that it would be different. He's given no factual basis for why these jury instructions would have changed the outcome of the trial. And even, I'm sorry. And here, that prejudice is just speculative, and this court and the Ohio Supreme Court and numerous other Ohio courts have held that mere speculation does not rise to the level of the prejudice required. And here, that's all we have. Thank you, Your Honors.
Thank you. You still have 4 minutes and 17 seconds.
Thank you. I think, when all three assignments there all sort of just kind of mesh together, and then when you look at the totality of this case, I mean, this really falls under the, no good deed goes unpunished. That's basically what happened to Mr. Nodal. And so, if for some reason this court is not fully convinced about the first assignment of error, well then, second assignment of error will kick in because trial counsel didn't object. And then if there's any, if the reasoning goes, oh, well, he didn't, pursue that line of defense, well then that's where the third assignment of error, comes in to say that's ineffective too, especially because it doesn't square with the fact, with what he was saying before trial. It doesn't square with his trial brief, it doesn't square with the proposed instructions, and, the facts of the case are such that, the only defense Mr. Nodal had to this, and which was a good defense, was that the arrest was unlawful, that there was a lack of probable cause. And, that was an essential element that the jury had to be instructed to consider.
There was an instruction, though, that said lawful arrest means you must decide whether the arrest was in fact lawful.
Correct, but there's more to it.
Right,
I mean,
I get what you're saying, but that instruction was given, is that right?
Yes, but when the jury is only told that, when they're not provided further definition, they're just, they need to be explained as to, well, what does the court mean by lawful arrest? I mean, 'cause ultimately, the jurors, they don't know the law. If the court's job is to instruct the jury on the law accordingly so that they follow it, and then, make their factual determination, and then apply those instructions of law to the facts, and then make their determination of guilty or not guilty. And the jury just was not provided all, the elements of what it means, what a lawful arrest means. And so there's just a lot more to it. They're just given a very broad, plain, definition, and, they're lay people, they're not attorneys. They have to be provided more specifics and more details, that, those little nuggets that we all know about, but they don't know, and they have to be educated on that. And it was the court's job to educate them. The one of the things that trial counsel did do right was that he proposed to the court how to educate the jury, but the court ultimately failed in its job to do that. And so, in the fact that the trial counsel proposed the instructions, that puts us under harmless error review. But even then, this still qualifies under plain error because it ultimately did prejudice Mr. Nodal. And then I explained that prejudice during the harmless error analysis in my brief. Just because I didn't repeat that point in the plain error section does not, I don't think, give this court license to just throw out the entire assignment of error. And I get into my reply about appellate rule 12A2, the language of 12A2, and the language of 1687. We can all differ on writing styles and everything, but ultimately the point was made, that Mr. Nodal was prejudiced by the poor jury instruction, by the deficient jury instructions, and then ultimately counsel did not stand up for him in the way he needed to, in both not objecting to the poor instructions, but also just not developing the theory of the case.
Well, he did get an acquittal on obstructing.
He did, but that's only half the. Half is not whole, and so it's just one thing I've learned in doing a couple even legal malpractice cases on the civil side is that a lawyer can do 99 out of 100 things right, but if the one thing he does wrong defaults the case against the client, and that's malpractice. And in this case, it's ineffective assistance of counsel. I mean, and so, again, he did the right thing when it came to filing a trial brief and propose instructions, like, that's great. But when it came to trial, it's almost like he just didn't show up and didn't deliver as he promised to the client as to what he was gonna do. And so, and there's case law where if the defendant has a very plausible, viable theory of a defense, like in State versus Underdown, where there's a viable theory that a third party committed the crime, and the attorney just made no effort to develop that factually in testimony and in evidence, that's ineffective assistance. So,
Thank you, counsel.
thank you.
Yes, you're allowed to go just a little bit over time, because I hate to interrupt people mid-sentence. Anyway, thank you both for your presentations to the court, and I would just mention to our intern that argued this morning, good luck to you. You stood your ground, and you faced some heavy questioning, so. And, but in regard to the case itself, we will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as, we release it on the Supreme Court website via email. So, thank you again, and enjoy the rest of your day. And